Mr Singh.
My Lords, the original structure of my submissions was really A, whether the representations were made, plus intention to induce, B, whether in fact there was inducement or the presumption was rebutted, C, consequential loss, and then D, the utility. And I was about to start after the adjournment on the second part, but can I just come back on a point which goes to the first issue, because we've been having a debate about I framed my submissions in terms of whether the representations were made, and as I say in paragraph 31 is one place where the principles are broken down in that way. And now the judge does seem to have looked within the question of whether the statements were made in the terms alleged. He does seem to have looked at what Mr Modi was intending to convey and also what meaning Mr and Mrs Marg understood. And he obviously found that there was neither the intention by Mr Modi nor the understanding. Now, we do submit that that was wrong. If I can just try and explain why we say that's wrong and then move on with my submissions. Ultimately, the reason we say that was an unreasonable conclusion was because it comes down to the nature of the alleged representations and statements in this case. So the parties' position, their respective positions in terms of the trial, the Margs were saying that what was said was that the individuals had already agreed to participate. The competing version of events from Mr Modi was that the statements were to the effect that these individuals would be approached in the future. Now, there may be some nuances around the oral representations, but if I just focus on the written representations to make good this submission, and in particular, let's take the investor pitch deck. So first of all, we have a document, which your lordships can see just as well as the trial judge could see. It's called an investor pitch deck. Your lordships have seen it has pictures and biographies of all of the individuals. I showed you, for example, page 5, the patrons section, where there's no qualification along the lines of intended or vision or proposed. It just says patrons. Page 11, the leadership team. It doesn't say vision or proposed, the leadership team. And page 115, the management team. It doesn't say vision or proposed. And I've shown you, and I've referred to this a number of times, but we do say it's significant. Dr. Shinawatra is referred to as the chairman with the present tense. Now, there was also the leadership board with the photos of the celebrities and a section entitled Brand Ambassadors, without qualification again. And we also rely, your lordships have seen this, another piece of written evidence, which your lordships can see just as well as the trial judge, the WhatsApp message sent in relation to Kofi Annan in August 2018. But that, of course, wasn't used at the meeting, so we can perhaps leave that to one side for present purposes, but we do say it bears upon the ultimate question. But if we stick with the documents that were shown at the meeting, we respectfully submit that on their face, they clearly say and mean that these people were already signed up. Indeed, that, we say, is not a point that requires a retrial, because your lordships can see that for yourselves. And my lord, we say that's clear on the meaning, just on the face of the documents, the meaning is clear. And that's before one gets to any questions of what did Mr Modi subjectively intend the meaning to be, or what did Mr and Mrs Marg subjectively understand the meaning to be. Now, with a statement as straightforward as one which is these people are signed up, which is what we say the statement is emerging from the documents, we say, in fact, detailed questions of what was the subjective understanding and what was the subjective understanding of the meaning, sorry, the intention and the understanding, they actually don't normally arise in cases where the statement is so plain. They normally arise in much more complicated situations. For example, implied representations and so on. What did the representee understand? But insofar as it is relevant to look at these sorts of points within the overall question of whether the statements were made, then essentially for the reasons I was submitting this morning, albeit I was making those submissions under the heading intention to induce, which was not an issue the judge ever dealt with at all, but I was dealing with them for completeness. But in a sense, for precisely those reasons, we say Mr Modi must have intended the representations to have been understood in that way. So if one thinks about the points I was making, the nature of the meeting, the need to raise funds, the reference to this as an investor pitch deck, and so on and so forth, we say for all of those reasons, it's utterly obvious, not only on the face of the documents, but also what he was intending the meaning to be, because that is the only way he would have induced investment, we say. Now, if one then looks at whether the margs understood the meaning to be that meaning, we say in relation to that, the statements, again, on their face, the statements were people had signed up. We say Mr. Modi intended them to be understood in that way. And we therefore say it would be a pretty remarkable outcome if they were not also understood in that way by the margs. Indeed, we know that they ultimately invested in this business. And we say insofar as the judge found that they didn't understand the meaning to be that meaning, he had no real basis for that finding, because all he really says in relation to this is, well, they weren't gullible people, so they should have rejected any such statements as boasts and puffs. And as I've submitted, that's problematic, because one only gets to the boasts and puffs question if one's assuming a statement was made that these people had signed up. But crucially, my lords, it was never Mr. Modi's case that these statements were made, but they should have been taken with a pinch of salt. The only dispute was whether, in fact, the statement was made. He never accepted that he may have said this, but they didn't understand it to be that meaning. He flatly denied ever making such a statement. So, my lords, we do, just to sort of summarise the submission on the first question, we do respectfully submit that the statements, the judge's conclusion that the statements weren't made, is that those conclusions are unsustainable. And insofar as within that conclusion he's made findings about intention and understanding of the meaning, we say those too are unsustainable. Now, I was going to turn to inducement. We obviously had a discussion earlier as to whether the judge has in fact made a finding in relation to inducement. So these submissions are on the premise that, as I'm sure my learned friend will submit, paragraph 13 of the supplemental judgment is something stronger in relation to inducement. I think their skeleton's very clear. They say the judge has found that there was no inducement. So let's assume, for present purposes, that the judge has in fact made a finding that the presumption of inducement was rebutted. As an aside, I would of course say the lack of clarity is a point again in our favour, the fact that we're here not even clear as to what the judge has or hasn't done. But in relation to the presumption of inducement, I'll just make 4 points. I can take them relatively shortly, because we only get to this stage of the analysis if statements were made in the terms. So your lordships have to accept, for us to get to this question, that statements were made in the terms alleged. Now, in my submission, if one assumes that Mr. Modi said to Mrs. Marg that all of the individuals had agreed to be involved, then it's utterly obvious that that would have been, at the very least, a cause of the ultimate decision to invest. Mrs. Marg and Mr. Marg said in their evidence that the involvement of the relevant individuals was a decisive factor when they were considering whether to invest. For example, paragraph 39 of Mrs. Marg's first witness statement and paragraph 57. And perhaps I'll just show you one reference to the transcripts. But as I say, it's an obvious point. If we can just look at day 2. It's the unagreed supplemental bundle. And just wanted to show you page 107, which is page 243 of the bundle. And if one looks at 107, line 23, Mrs. Marg says this was a very unique investor deck. This was an investor deck that had an amalgamation of individuals which are very, very special people, very, very notable, and very, very accomplished individuals. That Mr. Modi was able to pull together all of them and invoke their interest was very, very interesting to me. And so we say it's utterly obvious that if, given the prominence of these individuals, if she had been told that they were all signed up as patrons, leaders and brand ambassadors, then that would make this investment very meaningful and lucrative, as she says in her witness statement. So that's the first point, just the very nature of the statements.
I didn't get a clear note. Could you just remind me of the witness statement reference?
Yes, I'm sorry, my lord. Mrs. Margaret, paragraph 39, her first statement.
Yep.
And 57.
Yep.
And also, to similar effect, is Mr. Marg, first witness statement, paragraph 30.
Thanks.
Now, the second point in relation to inducement is let's look at their conduct immediately after the meeting, and we can see the messages that were exchanged with Mr. Modi in the agreed supplemental bundle. Behind tab 5. If your lordships look at about 2/3 of the way down, the message at 8:08 AM, Mrs. Marg says, Lalit, thank you for such an insightful evening and the indulgent hospitality. Brilliant 3.5 hours spent. Danny's going to write to you soon pertaining the holding company. And Mr. Marg sent a message to similar effect. If you lordships could look at page 67 of the bundle. I'm sorry, I think that's actually a false reference. If your lordship can look at page 62, it's the second message from Mr. Marg, so 14th of April. So this is again the same day as the meeting concluded.
Sorry, which page?
I'm sorry, 62. The second message, Lalit, it was a pleasure to see you and spend an insightful few hours. Thank you for your hospitality. I'll write in soon pertaining the ICO, which is something called an initial coin offering, and the investment into the holding company. And then if we look at the oral evidence on this, which was actually Mr. Marg at day 3. Page 63. Lines 10 to 21, if I could just ask the lordships to look at that. It's page 273 of the bundle.
I'm sorry, where are we looking?
My lord, it's day 3, page 63, lines 10 to 21.
Thank you.
And also page 65, lines 8 to 16. It's really the same point. That's really just to explain the references to the holding company and the messages are references to investing in the holding company. So that's the same day as the meeting concludes. One can see their immediate reaction, which we say is significant in the context of inducement. The next point is that there was evidence at trial that Mr. Modi put time pressure on people to invest. So again, relevant to the question of whether by the end of the meeting they would have indicated that they would be investing. In relation to this, could I show you, first of all, what Mrs. Marg was saying in her first witness statement? Which is Agreed Supplemental Bundle, tab 10. And it's paragraph 40 on page 141. So her evidence was the meeting finished at about 2:30 AM and Mr. Modi would not let us leave without me committing to invest then and there. This was not in a threatening way, rather he was so insistent, the opportunity presented so compellingly, that he presented it as a no-brainer. And Mr. Marg says something similar about the decision to invest being made at the end of the meeting. But what is significant is that there were documents before the judge which showed that Mr Modi used time pressure to induce people to make investments. So this happened in relation to another individual, Mr Srinivas, regarding a potential investment in iron care. And we can see the email exchanges between Mr Modi and Mr Srinivas in the agreed supplemental bundle behind tab 3. So these emails date from July 2017, so the year before the meeting with the Margs. And if one just picks this up at page 59, there obviously are some emails before this, but if we can pick it up at the bottom of 59 on the 28th of July, Mr Modi to Mr Srinivas, I confirm you will receive 6% of iron care. As you are aware, the next round of fundraising will be at valuation of close to 7 to 10 billion, based on us acquiring on Monday the entire cure business of CF, that's the CCU, and all its people. And one can then see on page 58, which is also the 28th of July, Mr Modi saying to Mr Srinivas, as discussed at close of banking today, the price of iron care moves up. So kindly note if funds are not in the bank or we do not get confirmation it's been done, I'm afraid you can still buy at the new price, i.e. the higher valuation. The offer expires in exactly 55 minutes. And then Mr Modi was cross-examined about that. Day 4, page 94. And if I could ask you to read page 94, line 4, through to page 96, line 12, where Mr Modi accepts that in fact he didn't believe, contrary to what was said to Mr Srinivas, that the valuation would go up. Now, of course, that wasn't a pleaded issue, as we were discussing this morning, but we do say it's striking that the judge didn't consider this evidence at all in his judgments, in circumstances where we say this makes it entirely plausible, indeed very likely, Mr Modi would have done exactly the same thing to the Margs, i.e. essentially request them or require them to commit to investing by the end of the meeting. And again, the context of all of this is whether the presumption of inducement has been rebutted. That's the target here. And then the fourth point I'd just make in this respect is the lapse of time between the meeting in April and the ultimate investment in November, we say is a non-point. So I showed your lordships paragraphs 81 and 92. The judge seems to have put a lot of weight on the fact that the investment wasn't made until November. In fact, the reference to November, in a sense, is not the right date in this context, because we know that Quantum was incorporated and the money was borrowed by Mrs. Marg in July. So actually the relevant question is more in relation to what was driving that decision. But in any event, insofar as the judge is saying in the judgment, paragraph 81, the Margs could have done things but didn't, then we say, well, that's irrelevant because as a matter of law, the representee doesn't have a duty to carry out due diligence. Insofar as they did do certain things, that's paragraph 92 of the judgment, we submit, well, those things were not sufficiently important to negate any causative impact of what might have been said or what was said on this hypothesis at the meeting. So if one just takes a step back again and looks at the commercial reality of this, we submit it's obvious that what was driving this investment was the very prominent and very large number of individuals. And it's the statements at the meeting which set the whole the whole process in train, because it's only because they've been told that all these people are signed up already that they go about doing the further work after the meeting. So we say it plainly was a causative factor all throughout the relevant period, and really, to the extent the judge has made a finding that the presumption of inducement was rebutted, we say there's absolutely no basis, given the points I've just made. So that then takes me to my third issue, main issue, which is consequential loss. And as I said at the outset, the criticism we make here is a different one. It's a short point that ultimately we found against the claimants on an issue which was not pleaded. We've referred to the decision of this court in Ali and Dink, which is behind tab 7 of the authorities bundle. Let me just show that to you briefly. It really just emphasises the importance of judges sticking to the pleaded issues, as it were. That's tab 7. If I could show you paragraph 19, where there's a quotation from Lord Justice Dyson's judgment in the Al-Madani case. In my view, the judge was not entitled to find for the claimant on the basis of the third man theory. It's fundamental to our adversarial system of justice. Parties should clearly identify the issues that arise, so that each has the opportunity of responding to the points made by the other. The function of the judge is to adjudicate on those issues alone. And so that's Lord Justice Dyson. And then if I could also ask you, in fact it's Lord Justice Nugee's judgment in the Satyam case at paragraph 23. I could just ask you to read that, and we emphasise the second half in particular. And then finally, if I could ask you to look at paragraph 25. So the judge must decide the case on the pleaded issues. And can I now show you the pleaded cases in relation to consequential loss? If we start, it's in the core bundle, particulars of claim. If I could ask you first to turn up page 127. And the consequential loss claim is pleaded at paragraph 34, 34A, B and C. Your Lordships will have seen reference to these alternative investments in the judgments. So two alternative investments identified, Live Space and B1T. And just so your Lordships can see, because this is important to the submission, for example, at 34, the references are setting aside the 1 million, and then but for the Iron Care investment, Mrs. Gilmarg and Quantum would have invested both the 1 million paid on behalf of Quantum to Iron Care and the additional 1 million which she and Quantum had agreed to invest. So it's an alternative. It's being said if we hadn't invested in Iron Care, we would have done as follows. And then if you can look at 43.2, which is just in the particulars of loss, 43.2 and 3. In fact, your Lordships would have picked up that the trial was split, so there was never any evidence about valuation. But that's the case as pleaded on consequential loss. But then what's important for the purposes of this argument is we then look at what the defendant was pleading back, if one could look at 147 of the bundle, which is paragraph 45 of the defence. Perhaps I could just ask your lordships to read all of paragraph 45, which is 2 pages. So essentially 3 arguments were being run by the defendant. 1, any alternative investment would not have been through Quantum, this particular SPV. 2, the terms of the loan agreement between Dunbridge and Tamares ultimately making the investment on behalf of Quantum, the terms only permitted the investment to be made in Ironcare. And then a third point was just putting the claimants to prove that they would have invested as much as 2 million in these alternative investments. Now, I don't need to turn to it, but in the reply, each of those 3 arguments was addressed. That's paragraph 27A of the reply, which is page 165 of the core bundle. But those were the pleaded issues. And I should say that those amendments to the defence were made, I think, in December 2021, so just a couple of months before the trial. And now, if I could show your lordships what the judge held in relation to this, at paragraphs 98 and 99. At 98, he says, I would be prepared to proceed on the basis that if Mrs. Margaret decided to invest in LiveSpace or invest more in B1T, she might hypothetically have formed and used Quantum for that purpose, rather than another SPV. He says, I'm sceptical as to the likelihood of this, but he says he's prepared to proceed on that basis. Then at 99, he says, Mrs. Marg said the maximum amount she typically invested was approximately $100,000 to 1.25 million. And then he goes on to say over the page, but among other things, it's unclear whether she would have had and used $2 million or any other necessary sum, A, in addition to the Dunbridge loan, or B, as an alternative use of that loan, which restricted other investments, if not for investment in Ironcare, or C, from other profits or Mr. Marg's salary and bonus. This seems to me too speculative to found sufficient case on causation. Now, there's quite compressed reasoning, but what the judge is saying in that latter part of paragraph 99 is that she hasn't proved that she would have been able to use the loan as an alternative, that's point B, given the provision which restricts the investment to Ironcare. But points A and C are essentially saying it's unclear whether she would have had 2 million in addition, so additional liquidity. In other words, she could have made the alternative investments in any event. And that point, the additional liquidity point, is the point that was never pleaded. It was put to Mrs. Marg in cross-examination, but it was never pleaded. And it was made clear in the claimant's closing submissions at trial that this point had never been pleaded. And I would like to show you what was said to the judge about this. Agreed supplemental bundle, tab 20. We've included an extract from the written closing submissions. If your lordships could turn to page 238 of the bundle, and it's paragraph 241 of the closings. I could just ask your lordships to look at that.
Sorry, which paragraph?
241, my lord, in bold, on page 238 of the bundle. And really the short point on this is that the judge, we respectfully submit, was not entitled to find against Mrs. Marg on the point that she could essentially have made this investment with additional liquidity, since that was not pleaded by the defendant. It was not therefore a point which was the subject of disclosure or the subject of Mrs. Marg's witness statements. And of course, she did give oral evidence about this because she was cross-examined about it. And a point that's made by the other side in their skeleton is, well, it's not surprising the judge ended up where he did given the oral evidence that emerged. But with respect, we say that misses the point. As the Dink case shows, the judge was not entitled to stray beyond the pleaded issues, and it's not fair, we respectfully submit, to find against the claimants in circumstances where this had not been an issue for disclosure or therefore addressed in witness evidence either. So that's paragraph 99 insofar as the judge has in mind the possibility of additional liquidity. He also has a point about liquidity in the alternative. So this is because the Dunbridge loan had a provision saying it was for the purpose of investing in iron care. But my lords, in relation to that, Mrs. Marg's evidence was clear, oral evidence, that the only reason that the loan agreement referred to iron care was because that was the investment that was actually being made. And if some other investment had been made in the alternative counterfactual, then that would have been permitted by the lender. So let me just show you the oral evidence on that, which is day 2. Page 43. And it's line 20 on page 43 through to page 45, line 9.
Sorry, so it was pages...
Page 43, line 20, and
Yeah.
page through to page 45, line 9. And
sorry, do you want us to read that?
oh yes, please. I'm sorry, my lord. And my lord, if your lordship's note, the loan agreement is in fact in the core, in the agreed supplemental bundle at page 120, and you'll see the relevant provision is clause 2.1, which says the loan has been made available to the borrower for the purpose of investing in Ironcare. And we say the judge has given no reason as to why the oral evidence that Miss Marr gave in that respect should be disregarded. And indeed, if one thinks about it as a matter of common sense, if one's thinking about the counterfactual, where the investment in Ironcare is not made, then we say it actually stands to reason that the investment would have been permissible and not prohibited by that provision. So, my lord, that's what I wanted to say about consequential loss, and I wanted to finish by dealing with the consequences of these points. For all the reasons we've given, we say the judge's decision is unsustainable and should not be allowed to stand. And if your lordship take the view that the judge didn't make any findings in relation to reliance or inducement, then that, of course, is a reason why this case needs to go back to a retrial, albeit your lordships could form a view as to whether, for example, a written representation was made. The reliance question would have been left open on that basis and would need to go back. Consequential loss, again, if your lordships are with me, that would need to be the subject of further disclosure and witness evidence and so on. And clearly, if Mrs. Marr were to succeed in the consequential loss claim, that would lead to a significant recovery in terms of damages. And so there would plainly be some considerable utility in sending this case back. But what is said against me is, well, if you're wrong about consequential loss, then there's no utility at all in sending this case back. In relation to that, we say two things. The first is there would be significant implications as regards costs. Now, we have the costs judgment in the bundle, in the core bundle. And I think I just need to show you what the judge did in relation to the Part 36 offer. The cost judgment is tab 8B. As we touched on earlier, although this was without prejudice material, I believe now it's in the judgment. So your lordships will see paragraph 3 of this judgment. Having succeeded on the breach of contract claim, Quantum calculated the amount of interest, bringing the total judgment sum in its favour to 931. And that the 1,001 days of interest ran from some date in the middle of 2019, so when the agreement was reached to repay, or the failure to repay by the 1st of May 2019. I don't have the precise date, but it's around the middle of 2019. That's how the total judgment sum was calculated. Then the judge says at paragraph 5, essentially the claimants failed to beat the offer, the Part 36 offer that had been made, inclusive of interest. And what then followed were arguments before the judge as to whether, first of all, the Part 36 offer, this is paragraph 6, should be treated as effective as of the 12th of January 2022, the date of the PTR, or the 27th of May 2021, which is 21 days after the date of the offer, i.e. the default position. And there was also an argument before the judge, which is dealt with later in the judgment, about whether the claimants should have their costs prior to the offer expiring. And the judge rejected the claimant's position on both points, and importantly for present purposes, he did so largely because of the failed deceit claim. So on the first issue, if one looks at paragraph 13, he rejects the argument about deferring the date of the Part 36 offer because the claimants would not have abandoned the deceit claim, which is what drove and drives them to the end, and perhaps beyond, he says. And at paragraph 15, he says the justice and fairness in this case applying the usual consequences of the claimants failing to accept an offer. All the more so when the deceit claim, which was so important and no doubt liable drastically to affect all parties' positions, has entirely failed. So clearly his decision on that aspect of the cost argument was significantly influenced by the deceit claim. And then on the second point about costs up to or prior to the Part 36, you can see what he says in paragraph 16. And so we respectfully submit that so far as costs are concerned, if Mrs. Marg were to succeed in relation to deceit, the cost position would need to be looked at again. And in relation to interest, as I say, the judgment that was entered included interest dating from the middle of 2019 based on the contract claim. And if we win the fraud claim, or if Mrs. Marg were to win the fraud claim, then obviously she would be arguing that she should have interest from 2018.
This is just so I understood where we are. This is if you lose your consequential loss claim, you'd still, you say, be entitled as damages for deceit to repayment of the 1 million plus interest from the date it was paid into Iron Care.
So, my lord, just to break that down, in terms of the principal sum, what was invested was 1 million.
Oh, you'd had 200 back, so it would be 800.
No, but that has been returned pursuant to the judgment through the breach of contract claim, and there was 1 million of the two which was never ultimately invested. So, but your lordship is right. The question I'm addressing is whether there would be any good sense in your lordship sending this case back.
Yes.
It's said against me, there would be good sense if we were right about consequential loss, but we're not. And I'm saying, even if that's right, which I don't accept, there would be utility, A, because it would potentially shift the costs judgment, because you've just seen it was very influential in his lordship's mind. Secondly, the interest point. Because the fraud claim is based on the decision to draw down the loan in July 2018, invest in November 2018, and set aside the other million, if the deceit claim were to be successful, we would be arguing at the relevant point in time that the interest should run from 2018 rather than 2019, which is what happened in the judgment, because the judgment was only on the contract claim. So I should emphasise, we would submit those are not points for today or for your lordships actually to determine. I'm just trying to illustrate. We say actually the beginning and the end of this is the consequential loss point, because if we're right, we should have another go at that, then obviously it's worth sending this back because the case could be worth many millions. But even if I'm wrong about that, the interest and the cost points would need to be looked at.
The interest would be, what, on the figure of 1 million?
No, we would say 2, my lord, because 1 was set aside as well. So in terms of the argument would be we've lost the use of 2 million, just because we've actually invested 1, but we've set aside the other.
But Quantum, this is Quantum's claim, the deceit claim.
Yes.
I think there was originally a claim pleaded by Mrs. Marg personally, but that was abandoned, is that right?
As I understand it, it was not pursued, yes, because the alternative investments claim was ultimately pursued on behalf of Quantum.
Yes.
And
so Quantum has no other business other than Iron Care. If you've lost the consequential loss plan, which is what we're looking at, then Quantum's financial position is it's drawn down 2 million from its parent, Tamares, who's drawn down 2 million from the uncle, Birchfield, to put into Iron Care, but it was never going to do anything else with it, and the terms on which the money was borrowed from the uncle was that he got a share of the upside if there was one. So why is Quantum out of pocket for not using the other million? Because it was never going to use the other million, except for Iron Care.
well, my lord, this is all something, as I say, it's not for your lordships to determine. The argument would go that Quantum had the money, and essentially, if your lordships, or if it were to be found that they would have made an alternative investment, then they would get the consequential loss. But if it for some reason the consequential loss claim was dismissed, then it would still have lost the use of the money, which the court would recognise through an interest amount. So your lordship's putting to me that it would never have had the money. I think the way in which it was argued below was that the arrangement should be treated as effectively a loan from Tamares to Quantum. So in other words, Quantum had money, some of which it invested, some of which it set aside, and it should plainly have the interest on the money which it invested, but it should the interest on the money that it invested. But insofar as it set aside further amounts, that was also money that it lost the use of. But as I say, this is very much down the pecking order in terms of why we say there's utility in this.
Well, you're not asking us to decide it, but I think I can see how you put it.
My lords, unless I can assist any further, those were my submissions.
How much difference would the interest make? I don't...
Oh, it's a very good question. And the answer is it depends, because it would depend on the date and also the rate. But there is a world in which the offer could have been beaten, if that's really the long and the short of it.
And just to be clear, if you were only worrying about the 1 million, not the 2 million, would the offer still potentially be beaten?
No. I would need to just verify that. But we are certainly putting it on the basis that the interest argument would be in relation to not only the one that was invested, but also the one that was set aside.
Yeah.
But I just don't know, because there are so many variables with the rates and the dates. I think there is. I'm being told there is a scenario, but I just don't want to give you chapter and verse, as it were.
Yeah.
Yes.
Thank you very much. Mr. Mill.
I wonder if I might just address the last point first, because in my respectful submission, your lordship should, if they can decide the point, decide it, because it may be relevant to the question of what remedy, if any, is afforded on this appeal. Your lordships may have seen, I hope they have, our supplemental skeleton argument, which deals with the question of costs and the calculation of interest. If not, could I invite their attention to it?
And I have had it.
Do your lordships have it?
I do. I think Lord Justice Singh does. I'm not sure Lord Justice Nugee yet.
I will find it. Yes. No, I have got it.
Got
Two pages.
It's only 2 pages with documents attached to it. But I think you may not have looked at the
No,
documents.
you're
for the
correct.
reason
Should I be getting them out or not?
Yes.
This is the correspondence, is it?
Yes, it's just it's the document that contains our Part 36 offer
Yeah.
and the antecedent document which generated the numbers within the Part 36 offer. And if your lordships just look at paragraph 2 of our skeleton, having set out the contention which we find in the appellant's skeleton, that if the deceit claim is upheld, that would increase the award of interest. We say that's without foundation. We refer to your lordships to the judgment on costs which you've just been shown, so I don't need to show that to you again. The amount of the respondent's Part 36 offer was set by reference to an interest calculation made by the appellants themselves, interest being calculated from the time of investment. And if you're, perhaps I can just carry on in the skeleton, then I'll show you the document. The relevant correspondence is attached, from which can be seen in a letter dated the 28th of April. Solicitors for the appellants made an offer to settle, which included a claim for interest on the sum of 800,000, calculated from the 13th of November 2018, that is the date of the investment, to the 13th of May 2021, a date 21 days from the offer. I've put 8% there. I think in fact it's 8.2%, which is 2% higher than the rate of interest which the judge determined should apply, in the amount of $164,000. And in response, we made the offer to settle the claim for $964,000, that is $800,000, plus the $164,000 they had intimated was their basis for the calculation of interest. And your lordships will find lordships, bear with me a moment. Yes, if you look at the footnote on the page 2 of the RPC letter containing the without prejudice favours to costs approach, they say it's 220,000 plus 800,000 return of the balance of the principal sum, plus 164,000 accrued interest calculated at 8.2% from the 13th of November 18 to the 13th of May 2021. and then a sum for consequential loss. So, my lords, my learned friend says that there is a world in which, if it's only the 1 million which is at stake, they can still beat the Part 36 offer. I don't understand what that world is, because here we've given them the benefit of not only the amount that they have claimed, but a rate of interest which exceeds what the judge said was appropriate. So I just don't understand how that can be. Now, I accept that if this appeal were to succeed to some extent, there may be a different consideration about the costs incurred before the Part 36 offer was made. But if one looks at the cost judgment, in order to see the amounts of money that would be at stake on that basis, your lordships will want to read paragraph 17 of the cost judgment of page 108, 8b of the core bundle.
Should we look at that now?
My lord, yes, please. So what the learned judge did in the circumstances that prevailed then was to make no order in respect of the parties' costs prior to the 27th of May. That's paragraph 18. What is clear from paragraph 17 is that the costs at stake prior to that were £165,000 in terms of budget. Now, that may not be precisely right, but that gives you an order of the sort of money that might be to be up for grabs. And in my respectful submission, if that's all there is, the court should be very, very reluctant indeed to order a retrial. I obviously accept, if your lordships are with my learned friend on the consequential loss claim, that these submissions fall away. But if your lordships are with me on the consequential loss claim, the idea of having a retrial of all these events that took place 5 years ago, where the most that's at stake is a small figure in 6 figures, is not one that can realistically be anticipated as being appropriate or proportionate, in my respectful submission. Lords, what I propose to do now, and for the rest of today, insofar as that it takes up that time, is to do a little work on the law and draw your attention to some features of the evidence and the judgment which have not been shown. What I propose to do then, if I may, is to invite the court to rise. And the reason why I'm doing that is because I find myself having to face a whole different set of submissions to those that I had read and anticipated in dealing with today. And that's not a criticism of my learned friend, but it's fair to say that the acquaintance between the original grounds of appeal, the original appellant skeleton, my learned friend's supplemental skeleton, and the way he's put the case today is, in part at least, a passing one. And I think I can do better justice to what your lordships will find useful if I can address that. And I've made notes on it, but I think I can deal with them more efficiently tomorrow, by your lord's leave, if I'm finished before 3:30.
Yes, let's take the law and the features of the evidence of the judgment that we haven't seen, and then I'll just check how my brethren feel about stopping at that stage.
I mean, I'm happy to carry on, but I'm just not sure it's
Yes,
best
it's going
use
to be
of the
efficient.
court's time. That's all.
Yep.
So, my lords, on the law, what I wanted to do was to show your lordships a couple of the cases which I have added to the bundle and which are not therefore dealt with in the written submissions. They are the last 2 tabs of the bundle. One is the Supreme Court decision in McCraddy, and the next is a decision of the Court of Appeal in Wealden. McCraddy is, of course, referred to in Henderson, but not, its terms are not then set out. And, my lords, page 181 of the bundle. If I could start with paragraph 2. The principles stated in Thomas and Thomas, which are set out in 1, long been settled law. An appellate court should intervene only if it satisfied the judge was plainly wrong. According as was said by Lord Green in Ewell, in a dictum which was cited with approval in Thomas, it can of course only be on the rarest occasions and in circumstances where the appellate court is convinced by the plainest of considerations, as it would be justified in finding the trial judge had formed a wrong opinion. The reasons justifying that approach are not limited to the fact, emphasised in Clark's case and Thomas, that the trial judge is in a privileged position to assess the credibility of witnesses' evidence. Other relevant considerations were explained by the US Supreme Court in Anderson. The rationale for deference to the original finder of fact is not limited to the superiority of the trial judge's position to make determinations of credibility. The trial judge's major role is the determination of fact, and with experience in fulfilling that role comes expertise. Duplication of the trial judge's efforts in the Court of Appeals would very likely contribute only negligibly to the accuracy of fact determination at a huge cost in diversion of judicial resources. In addition, the parties to a case on appeal have already been forced to concentrate their energies and resources on persuading the trial judge that their account of the facts is the correct one. Requiring them to persuade 3 more judges at the appellate level is requiring too much. As the court has stated in a different context, the trial on the merits should be the main event rather than a tryout on the road. For these reasons, review of factual findings under the clearly erroneous standard that this deference to the trial fact is the rule, not the exception. And then similar observations are made by Lord Wilson in Newey B. Furthermore, as was stated in observations adopted by the majority of the Canadian Supreme Court in Howson, the trial judge has sat through the entire case, and his ultimate judgment reflects his total familiarity with the evidence. The insight gained by the trial judge who has lived with the case for several days, weeks or even months, may be far deeper than that of the Court of Appeal, whose view of the case is much more limited and narrow, often being shaped and distorted by the various orders or rulings being challenged. And then in Wealden, Lord Justice Coulson quoted from the decision of Lord Justice Lewison in Fage at paragraph 7, what he describes as a memorable summary. Appellate courts have been repeatedly warned by recent cases at the highest level not to interfere with findings of fact by trial judges, unless compelled to do so. This applies not only to findings of primary fact, but also to the evaluation of those facts and to inferences to be drawn from them. Best known of those cases are, and then they're set out, most recently McCready. These are all decisions either of the House of Lords or of the Supreme Court. But the reasons for this approach are many. They include, 1, the expertise of a trial judge is in determining what facts are relevant to the legal issues to be decided, and what those facts are if they are disputed. 2, the trial is not a dress rehearsal. It is the first and last night of the show. Duplication of the trial judge's role on appeal is a disproportionate use of the limited resources of an appellate court and will seldom lead to a different outcome in an individual case. In making his decisions, the trial judge will have regard to the whole of the sea of evidence presented to him, whereas an appellate court will only be island hopping. The atmosphere of the courtroom cannot in any event be recreated by reference to documents, including transcripts of evidence. Thus, even if it were possible to duplicate the role of the trial judge, it cannot in practice be done. And just one other passage before I make 1 or 2 observations by reference to that, and that is the Symetra case. Should be at tab 6, if your lordship's find it. Paragraph 37 on page 108. The quotation from Lord Sumption in the case of Volcafe. This court has on a number of occasions pointed out that while an appeal to the Court of Appeal is by way of rehearing, the trial judge's findings of fact should not be overturned simply because the Court of Appeal would have found them different. It must be shown that the trial judge was wrong i.e. that he fundamentally misunderstood the issue or the evidence, or that he plainly failed to take the evidence into account, or that he arrived at a conclusion which the evidence did not on any view support. Within these broad limits, the weight of the evidence is a matter for the trial judge. There is a world of difference between the impression which evidence makes on a judge who has followed it as it was deployed and the impression that an appellate court derives from cold transcripts. Lords, what has happened so far today is precisely what the House of Lords of the Supreme Court have warned against in the passages which I have cited. There has been a selective presentation of some of the evidence to the court. A presentation which has involved additional documentation, a whole unagreed bundle, hundreds of pages, in order to put across an argument to this court. It cannot, on any view, in my respectful submission, be right that in those circumstances it can be said that if your lordships were to be persuaded, they would be persuaded by the plainest of considerations. Clearly, what is envisaged in these cases, in my respectful submission, is that very rare occasion where it can be shown pellucidly, transparently, and succinctly that the judge has obviously, plainly gone wrong. I listened to my learned friend today. This is the fourth iteration of an attempt to find things that are wrong with this judgment. Fourth iteration being the grounds of appeal, the original skeleton, supplemental skeleton, and today's presentation. And it's all far too diverse and complex. And for your lordships to find that there has been an error such as to entitle the court to find that no reasonable judge could have come to this conclusion is just not one that this court should be countenancing, in my respectful submission. On that point, my Lord Justice Newey suggested to my learned friend that if your lordships were to come to the conclusion that this was a decision which the judge could not reach, there would be no basis for a retrial for the reason given by my lord, which is that on that basis a retrial couldn't come to any different conclusion. That is correct, with respect. And therefore the circumstances in which there can be a retrial can only be where the basis for it is not that the judge could not reasonably have come to that conclusion. It would have to be one of the other bases, which is lack of reasons, failure to take into account evidence, and the other circumstances which are defined in Henderson in the passage which probably should remind your lordships of.
Mr. Bill, did you also submit to this court that the mere absence of reference in a judgment to a particular piece of evidence does not necessarily lead to the conclusion that the judge did not take it into account?
Lord, I would and could make that submission as a matter of generality, but I don't even need to do that in this case because the judge has made it clear that he considered every aspect of the very lengthy 94-page closing submissions of the claimant and has taken everything that is there referred to into account in his judgment. And you will find that at paragraph 89. This is where he, as it were, mops it all up and brings it all together. He says, the above represents an overarching summary of what is, in my judgment, some of the most telling aspects of the evidence on liability for deceit. Given what I've said about that, and despite the plethora of other details in Quantum's lengthy submissions, all of which I have carefully considered, which are not necessary here further to recite.
I'm always a bit sceptical about formulae such as that.
Well, my lord, I understand to some extent what you say about that. But what is a judge meant to say? If in fact he has done what he said he's done, and puts it in his judgment. I mean, unless there is some reason to suppose from the judgment itself or the conduct of the trial that the judge hasn't done that, then you should take it at face value. The judge is entitled to that element of respect, with respect. And what is quite clear, sorry, my lord.
No, I was only going to say, if I may respectfully say, judgments have become far too long as it is.
Well, that is certainly true, and so have closing submissions.
The more often this court says to first instance tribunals that you've missed that out, you've got to put that in.
Yes.
We all know what happens. It leads to defensive judgment writing, which tends to obscure rather than clarify the main points.
My lord, yes.
We often criticise, if I may say so, counsel for giving us a 100-page document when a 25-page document would have sufficed. And the Lord Chief Justice has made the point that prolixity tends to obscure rather than illuminate what actually is going on.
I respectfully entirely agree with my lord, and could I just make this observation, having done what I'm sure my lords have done, which is to look at the transcripts carefully. Maybe I've looked at more than your lordships have, because I thought it was appropriate to do so. What is absolutely abundantly clear is that this judge was all over the evidence. He didn't interfere, he intervened appropriately. He was clearly actively engaged, asking questions about all aspects of the evidence. There is absolutely no reason to suppose that when he says he took everything into account, he didn't. So whatever one might say is a level of generality about the point my Lord Justice Newey has made, there is nothing in my respectful submission in this case that suggests that the judge did not do exactly what he said he would do. And he, in my respectful submission, correctly identified what was necessary and what was not necessary. And that's all you need to do as a judge, to deal with the key points, as my Lord Justice Singh, I think, is alluding to. Don't have to deal with each and every point. What is clear is you have to show a sufficient acquaintanceship with all the issues in order to be able to answer them, which is what this judge has done. Could I turn to my skeleton and just remind my lords of some of the findings that were made by the judge in this case. Paragraph 16 on page 48, tab 4. These are findings which the judge made on the evidence. Some of them your lordships have seen today, some of them you have not. So while the judge described Mr. and Mrs. Marg as impressive people, clearly experienced and sensible in business, he nevertheless found the manner in which each gave evidence was problematic for different reasons. Mrs. Marg veered between dogmatism on aspects which accorded with the central scenario and agenda of Quantum's deceit damages claim, and a rather disdainful vagueness on other relevant matters. Mr. Marg was prone to avoiding direct questions and going beyond the precise and into the pedantic. And then this, the judge did not believe the Margs' evidence, that they understood and relied upon the IPD document in the manner contended for by Quantum. Now that is a finding which has to be set aside in order for this appeal to have any prospect of success. Quantum's allegation that Mr. Modi and his son had engaged in deliberate systematic deletion of important internal family messages once they knew that litigation was in prospect, in order to evade their disclosure obligations and defeat Quantum's claim, was rejected. This allegation was a further example of Quantum's tendency to overstatement, a tendency the significance of which was not lost on the judge. Quantum's allegation in this respect cast doubt on the strength of its claim in deceit. The judge doubted Mr and Mrs Marg's explicit evidence that Mr Modi and or Mr Khanna told them that NDAs were in place with individuals named by Mr Modi at the meeting. The allegations made by the Margs made little sense. Mrs Marg's claim, expressly supported by Mr Marg, that by the end of the meeting she had committed to investing in Ironcare, was false. The Margs claimed that at the end of the meeting Mrs Marg had entered into an oral contract to invest $2 million in Ironcare, valued at 2%, was also false, and flew in the face of commercial plausibility and the contemporaneous documents which the Margs were unable to explain in cross-examination. And rolling that all together, Mr and Mrs Marg's witness evidence in relation to the meeting could not on the whole be relied upon for matters of undocumented detail. Now, there is no challenge to that conclusion. And that means that the documented detail has to take centre stage on this appeal. And Mr and Mrs Marg's oral evidence beyond that is of no value. I wanted to take you next to the IPD. And I want to do that in order to emphasize one particular aspect about it. So that's in the unagreed bundle. I'll find it. Tab 1. I'm just going to show you some pages, and then I'm going to draw some conclusions from them. These are examples of the point that I wish to make. Page 49. An empty page with the word trustee written in it. Page 50, CEO, empty page. $59. This is in relation to their brand ambassador. Underneath the name of Mr. Shah Rukh, suggested.
Shah Rukh Khan.
Shah Rukh Khan, I'm so sorry.
He's a famous Indian actor.
Certainly looks like it. Mr. Shah Rukh Khan, a suggested celebrity investor. And if you go over the pages...
I mean, that express reference to suggested might count against you, might it? In the sense it hasn't been said that all the others are suggested.
Well, what I'm talking about here is what a reasonable person reading this document would understand it to mean in the context. And part of the context is how the expression is made. I mean, I'll give you some more pages.
Yes.
But I don't accept for one moment that that's against me, because what this is clearly is a draft. It's an incomplete draft. And anybody with the knowledge and expertise of the Margs would have fully understood that. You can't rely upon a draft document in the way that they suggested that they did. So I've made that point on the ambassadors. Page 74, we have a TBC and another one at 76. We then have something called business plan at 78. And as far as I can see, no business plan follows it. We then have the Ironcare medical team at 82. And as far as I can see, no medical team follows it. We then have an executive summary starting at 84, which goes on for a few pages. And we then have something called introduction at page 88. How that differs from what's gone before, I'm not entirely sure. We then have a heading at 91 called Our Focus and Advantage. And then what follows is a whole load of documents about the nature of the science that's going to be promoted by the company. And then we have 108 strategic partners. And if you look at pages 112 and 113, companies showing or confirmed interest, and we can see a whole load of blank paragraphs and columns, and what is filled in is obviously very partial. We then have the management team. Mr Modi has dealt with over 3 pages at 117 to 119. His biography finishes in the middle of a sentence on page 119. Page 183.
Which is the sentence that's unfinished.
Well, yes, it may be the sentence is unfinished, but it's simply symptomatic of the fact that this is an unfinished draft.
You're referring to the sentence on 119, aren't you?
I am,
also
yeah,
jointly
which just finishes
established
in
the
the middle of the
Champions League
sentence.
2020, which remains the most profitable event in.
Mine says in cricket's history.
Oh,
Oh.
does it?
I'm looking at the colour copy, which is
I'm afraid I've stuck with my black and white one because I'd marked it up. In that case, I would draw that point, insofar as the colour one, if that's what they got, would have shown the rest of that sentence.
Well, it does suggest that there's more than one version floating around.
As I understand it, this is a colour version of the black and white. Anyway,
Well, it clearly
if your
isn't-
lordships
it's
find
not-
any
it's not exact-
any other differences when I go through it, doubtless you'll draw them to my attention.
Mr. Miller, it's not exactly the same. That's the point. Because where the word in appears is at the end of a line on our page 119 in black and white, and it's not at the end of a line in the colour version.
Well,
That may be a very small point, but it may underline your more fundamental submission that whatever we've got at one in the bundle
yes.
in black and white,
Well,
that may or may not be.
all I can tell you is it was represented by the appellants when they gave us these documents yesterday. This was simply a colour version of one that is in black and white in the bundle. Maybe that's not right.
Can I just clarify? The version in the bundle, the existing version in black and white, as I understand it, obviously I wasn't at the trial, but I think it was common ground the documents that were looked at the time were in colour, but I think on the Opus system they were coming up as black and white. Now, we thought it would be helpful for your lordships to look at a coloured version. I was told they are identical. If they're not, obviously I ask your lordship to just confine yourselves to the black and white version, which is the version ultimately that everyone was looking at trial. But I don't believe there shouldn't be many differences, because I was told yesterday that there are no differences.
Even one casts doubt on the entire document. That's the problem.
I agree. No, I completely understand that. That's why I say your lordship should look at the version that's always been in the bundle.
Well, I've taken mine out.
Well, Lords, I'm about to finish this submission, but I'm next going to go to page 183.
I see now that the black and white version has an RPC, no out of disclosure number
Yes, indeed.
bottom
That's
left. That doesn't appear in the colour version.
No, does it not? And certainly that RPC number is the number that is used in the appendices to the witness statements of Mr. and Mrs. Margus, the documents that they were looking at.
Well, it's
And
very
they
nice to have
refresh their memories from it.
colour copies, but I'm going to discard the colour copies and put back the black and white one. Sorry.
Not at all. My lords, the next page was 183. Project Vision, TBC, draft only. And 184, I particularly like this one. Second paragraph, the current scheme consists of 4 number of operation theatres with an average of 500 square feet each, 225 number of beds with an average 300 square feet each. This number has been wrongly calculated and as such project cost will reduce by bringing this down. Mazar to work on it. Now, as I understand, sorry, I think I've got one more. Oh yes, just a whole load of pages at the back, beginning at 202. Just a whole series of empty pages. Mrs. Marg's evidence was that Mr. Modi did a page-by-page run-through of this document. What is completely lacking from her evidence is an acknowledgement that clearly what she was being shown by Mr. Modi was a draft document. A finding that the judge unsurprisingly made. Sorry, not that she hadn't referred to it, but the fact that it was a draft, and self-evidently so. And that fact has to be taken into account when one considers what representation might be made from the leadership document, provided at the same time with copies of pages from the front cover of magazines and the like. And in a similar vein, if we look at the agreed supplemental bundle, tab 1, we have the information memorandum, which you were shown one page from my learned friend. We look at page 3. There is the word proposed in relation to the board of directors. Now the Margs gave evidence that they didn't consider that to be particularly significant. I can come to that evidence, maybe I'll do that in the morning. In my respectful submission, that just doesn't make any sense, because the word proposed is all of a piece with the status of the other documents which they received at the meeting, and they received this information memorandum 2 days later. Actually, maybe I can go to this. So maybe we should go to the evidence. In the unagreed bundle, this is Mrs. Marg's statement, tab 10.
Do you mean unagreed or supplemental?
I think I mean unagreed. Maybe I mean agreed. Your Lordship is quite right. So if we turn to page 142, paragraphs 43 and 44 and 45, perhaps your Lordships could read those paragraphs to themselves. Lords, the explanation given by Mrs. Marg in paragraph 44 as to what they understood, she and her husband understood by the word proposed, makes no sense. She says it's simply a matter of timing, depending on when they assumed their roles once funding had been called upon. That doesn't explain the word proposed. That's clearly a construct after the fact, designed to try and deal with the fact that the word proposed otherwise indicates an understanding on her part that these documents were simply in draft form. And in similar terms, paragraph 45, where she said she did not consider it to be a draft. My respectful submission ignores the fact that the other documents that she'd received together with the word proposed clearly indicates that it was. And Mr. Marg, tab 12 of the same bundle, paragraph 40, that evidence was similarly not credible.
I note that he says in the fourth line, we had already decided to invest
Oh yes,
in Ion Care before receiving the Ion.
he did. Well, that was their evidence, wholly rejected, and correctly so by the judge, that at the end of the meeting, I mean, I can show you the evidence on this, maybe I'll do that in the morning, give you something to look forward to. But I mean, wholly incredible evidence that there was an oral contract under which they had committed legally to invest at the end of the meeting. And the judge, unsurprisingly, rejected that out of hand. Made a note to take your lordships at this point to the judgment, paragraph 75. Whether any judge refers to the word proposed. It says Mr. and Mrs. Marg came to know who were the directors and knew that most of the non-Modi individuals had not been appointed. Their case that they were misled into believing that Sheikh Nahyan and others outside the Modi group, including Dr. Shinawatra, had agreed to be appointed later, is evidentially thin at the very least. I was next actually going to go to the evidence about the point raised by Lord Justice Singh, which is that about the release of Mr. and Mrs. Marg at the end of the meeting by way of commitment. Maybe I can't put that joy off, so I take my words to Mrs. Marg's witness statement at paragraphs 40 to 41. So that's tab 10. Page 141, overleaf to the top of 142. Maybe your lordships could just read that, those paragraphs themselves.
is that actually suggesting a contract?
Well,
I mean, it doesn't look to be if it's subject only to raising the capital and reviewing any further documentation.
I think your lordship has to read this together with the transcript of evidence.
Yeah.
So it's day 2, page 248 of the bundle. And your lordship will need to read page 126 from line 13 to 127, line 3.
We'll do that.
Then, when your lordships have done
Sorry,
that,
just hang on one moment.
I'm so sorry, my lord.
Yeah.
And then Mr. Marg's evidence on day 3, page 276 of the bundle, page 73 internal to page 75. Again, your lordships would read that
Yeah.
to themselves. Finish at line 12 on page.
Yeah. So the judge obviously had the same instinctive reaction as me.
Yes. My lords, if that's not inconvenient, that would suit me as a place
Yes.
to stop.
Let me just check.
Yeah.
So, Mr. Bell, how long do you think you'll be tomorrow?
Well, it's always dangerous to say this, but part of it may depend on the extent to which your lordships wish to press me on certain matters or not on certain matters. But I would hope with a clear wind, I should finish by lunchtime.
Fine. Well, in that case, we'll break now and we'll start again at 10:30 in the morning.